Article 4 of the Charter of the United Nations says that membership in the United Nations is open to all other peace-loving states which accept the obligations contained in the present Charter and, in the judgment of the organisation, are able and willing to carry out these obligations. In the early years of the UN, the early years of the Cold War, a range of new nations had made applications to join the United Nations. An application was first considered by the UN Security Council, which then made a recommendation to the General Assembly. The UN Security Council includes 5 permanent members: France, Russia, China, the UK, and the United States. These countries have a veto over UN Security Council resolutions. You can see that not all countries are equal in the United Nations. In those early years, when countries applied to join, their applications were often vetoed by what we might think of as the other side. The United States would veto applications by newly communist countries, and the Soviet Union, now Russia, would veto the applications of nations who were contrary to its interests, regardless of whether the applicant nation was a peace-loving state which accepted the obligations of the UN Charter and was able and willing to carry out those obligations. This conduct threatened the ability of the United Nations to provide a forum where all the nations of the world could resolve their differences. Eventually, the UN referred a question to the International Court of Justice, asking whether Security Council nations were allowed to consider factors which were not in Article 4 of the UN Convention. Or were Security Council members required to vote yes if a nation was in fact a peace-loving state which accepted the obligations of the UN Charter and was able and willing to carry out those obligations? The court found that the only way to decide was to look at the plain words of the provision. They said the court must, in the first place, consider the text of that article. To warrant an interpretation other than that which ensues from the natural meaning of the words, a decisive reason would be required, which has not been established. This has become a fundamental rule of the interpretation of treaties. We start with the natural meaning of the words and only depart from that natural meaning if there is a decisive reason.